Namaste and welcome back to Lahari's classes. Welcome to article by article series of Indian polity. This is part 3, fundamental rights. In the previous video, we have discussed lecture 1 of fundamental rights from articles 12 to 18. In this lecture, we are going to learn from articles 19 to 28. So let's begin. Articles 19 to 22 talks about right to freedom. Article 19 speaks about 6 freedoms, that is speech, assembly, association, movement, residence, profession. Article 20 speaks about protection in criminal laws. Article 21 deals about right to life and personal liberty. Article 21A talks about right to education. It was added by 86th Amendment Act. Here you can observe capital A, which means that any article that has been added by an amendment to the Constitution. Article 22 deals about protection in arrest and detention cases. So let us understand Article 19 in detail. So it actually protects certain rights regarding freedom of speech. Article 19 Clause 1A talks about freedom of speech and expression. That is, you can have a complete freedom of whatever you can express, your speech, anything. And Article 19(1)B talks about freedom to assemble peaceably and without arms. Anywhere you can assemble and discuss, have meetings, but without any arms and ammunitions. Next, Article 19(1)C talks about freedom to form associations, unions or cooperative societies. A group of people can come together and form associations to put their agenda, to put their demands to the state or to their employers, whatnot, anything. And Article 19(1)D talks about freedom to move freely throughout the territory of India. Any person from extreme south to extreme north or east or west can travel anywhere throughout the territory of India. Next is Article 19(1)E, that is freedom to reside and settle in any part of India. Anybody can reside anywhere and get settled in any part of the country. Article 19(1)F that actually has been omitted, that is repealed by 44th Amendment Act 1978, which was right to property. And after the omission, the right to property has been made to move to Article 300A, which made it a legal right from earlier being a constitutional right. So the status of right to property as of now is it's a legal right but not a constitutional right. And the last one in Article 19 Clause 1 is 19(1)G, that is freedom to practice any profession or carry on any occupation, trade or business. Any kind of profession you can take up, and any kind of occupation you can do, any trade or business, anything up to you. You have all the freedom to do so. But in order to enjoy all of these freedoms given to you, there are certain reasonable restrictions. Your freedom should not be harmful to others' freedom or others. It should not threaten others. The freedom is not absolute. It comes with reasonable restrictions, and those restrictions are in the interests of sovereignty, security, public order, decency, morality. Largely on the public order and sovereignty. So whatever the freedom you have been given, it should not disturb others' freedom, others' morality, or it should not disturb the public order, and it should not cause any harm to others, and it should be in the interest of sovereignty and integrity of the nation. Next is Article 20, which talks about protection in respect of conviction for offences. So Article 20 Clause 1 talks about protection against retrospective criminal laws. That is, let us see the statement first. No person shall be convicted of any offence except for violation of law in force at the time of the act, nor be subjected to a penalty greater than that prescribed when the offence was committed. So in simple words, I'll explain you. For example, in 2025, there is no legal act that criminalizes a public smoker. So anybody who smokes in the public is not put behind bars in 2025. But let's suppose an act comes in 2026. Suppose and it says that anybody who smokes publicly will be jailed for 3 months. Let's suppose. That doesn't mean that those who have smoked before 2026 will all be put behind bars. No, the act will apply from 2026 onwards, and on those people who smoke publicly from and about 2026, not any time before that. And next is Article 20 Clause 2. It talks about doctrine of double jeopardy. That is, no person shall be prosecuted and punished for the same offence more than once. I'll explain you in simple words. For example, a thief has been caught and the crime has been proved by the police. The same police cannot file another case for the same theft. Only one time the case can be filed and one time the punishment can be given. Only for once. So for the same crime, only once it can be punished, not more than once. Understood? Next one, Article 20 Clause 3. It talks about protection against self-incrimination. See, if someone is accused of any offence, and in the process of gathering the evidences, he or she should not be compelled to be a witness against himself. That is, he should not be forced to accept the offence, even if he has done or not have done that crime. But orally, they cannot be forced to agree to the crime, but they can take biological evidences like fingerprints, hairs, nails, etc. But orally, they cannot be forced to self-incriminate themselves. That is, they cannot be compelled to be a witness against themselves. Next is Article 21. That gives protection of life and personal liberty. This is the most important article. Many examinations have asked many questions on this article. So Article 21 guarantees that the state cannot take away anyone's life or personal liberty unless it follows a fair, just and legal procedure. So without following any law, the state cannot arbitrarily take away a person's liberty or restrict their life. So it has to follow a procedure, a valid law, and it should be fair. So in the Menaka Gandhi case, the court has said that the Article 21 should not be taken away, and that if so, it should be fair, reasonable, and non-arbitrary. Over the time, with multiple judgments, Supreme Court has included so many rights under Article 21. For example, right to privacy in the Justice K.S. Puttaswamy case in 2017, right to clean environment, right to livelihood, right to education, right to speedy trial, right to health and medical care, right to die with dignity, and right to choose a life partner, etc. There are so many rights with multiple Supreme Court judgments have been added to Article 21. So Article 21A, actually it is right to education. This has been inserted by 86th Constitutional Amendment Act 2002. It says that the state should provide free and compulsory education to all the children of age to 6 to 14 years in such a manner as the state may by law may determine. So this right is part of their right to live with dignity under Article 21. So any child who is in between 6 to 14 years must be provided with free and compulsory education. For that, in order to implement this right, the government has made this act, which is Right of Children to Free and Compulsory Education, RTE Act 2009, to give effect to this article. So it puts a duty on the state and parents to ensure the children are attending the school. And Article 22, it gives protection against arrest and detention in certain cases. So Article 22 Clause 1 and Article 22 Clause 2 discusses about rights of a person arrested under ordinary law. Article 22 Clause 1 says that the arrested person must be told the reason for arrest. There should not be any arbitrary arrest. No police can go to a person and arrest him arbitrarily. There has to be some reason, and they have to tell the reason to that person. Has the right to, and the accused person has all the right to consult and defended by a lawyer of his choice. And Article 22 Clause 2, that person who has been arrested by the police must be produced before a magistrate within 24 hours of arrest, and he cannot be detained beyond 24 hours without the magistrate's permission. So this is the a very important fundamental right, which gives protection to this arbitrary arrests and arbitrary detentions and all. Next is Articles 22 Clause 3 to Clause 7 discusses about preventive detention, that is detaining a person to prevent a future offence. If someone has committed some offence, some disturb the public order and all, he will be detained so that he will not perform any kind of future offence. So 22 Clause 3 talks about the above rights, that is to be told the reason, to have a lawyer, to be present before the magistrate within 24 hours. Do not apply to enemy aliens and persons detained under preventive detention laws. Next is 22(4). A person under preventive detention cannot be held for more than 3 months unless approved by an advisory board. Article 22 Clause 5. The detained person must be told the reasons and given a chance to represent against it. As we discussed in Article 22 Clause 1, very similar lines, that he must be given a chance to represent against that arrest. Next is 22 Clause 6 talks about the government may withhold information if it thinks disclosure is against the public interest. Because the government may withhold the information because that person who has been arrested may influence the evidences or public, and it may cause public disorder. So in that cases, the government may withhold information. Article 22 Clause 7. Parliament can by law extend detention beyond 3 months and specify maximum period of preventive detention. That is, we have separate laws for preventive detention. In those laws, the Parliament can make certain amendments or bring a new law so that the extension could be made beyond 3 months. And Articles 23 and 24 talks about right against exploitation. These are very important articles. Article 23 Clause 1 talks about prohibiting human trafficking and forced labor, begar, that is forced labor without payment, and other similar forms of forced labor. In ancient history, we must have learnt about vetti, which is forced labor. People are made to work forcefully, but they were not paid anything back for their labor. And anybody who violates this right is punishable by law. So basically 23 Clause 1 talks about forced labor, and 23 Clause 2 talks about the state to impose compulsory service like military service or social service, but without discrimination based on religion, race, caste, class, etc. during emergencies. So as a responsible citizen, if you are called to work in emergencies you have to go and present. So that is not considered under forced labor or any, that is not considered as exploitation. It is considered as service to the nation. Next is Article 24. That is, no child below the age of 14 years, less than 14 years, shall be employed to work in any factory or hazardous employment like mines and all. Any child less than 14 years should not be made to work in factories, mines, or any hazardous workplaces. Articles 25 to 28 talks about right to freedom of religion. So Article 25 says freedom of conscience and free profession of religion. Article 26 describes how, managing the religious affairs. Article 27 talks about tax. There is no tax for promotion of any particular religion. And Article 28 talks about no religious instruction in state-run schools. That is government-run schools. Article 25, that is freedom of conscience and free profession, practice and propagation of religion. It simply means that in Article 25 clause 1, it says that according to your inner voice, according to your conscience, whatever your wisdom says to practice a particular religion, you are absolutely free to practice that religion. It's absolutely your choice whether to follow or not follow any religion. And it also gives the freedom to profess, declare one's faith, and practice, perform religious acts and rituals, and propagate, also to spread or share religion. But in the name of propagation, you should not force someone to convert to your religion. It is against the public order, morality, and your practice of religion should not harm your health or others' health too. So these are reasonable restrictions on this Article 25. Next is Article 25 clause 2. This clause allows the state to regulate or restrict religious practices in certain cases. It has two parts. That is, the state can make laws to regulate or restrict any economic, financial, political or other secular activities related to religion. That is, you can manage your temple finances, you can manage your mosque finances, or a church or a gurudwara finances, and you can manage your religious institution. The state can make laws to ensure social welfare and reform, or to open Hindu religious institutions to all sections of Hindus, like allowing Dalits entry into temples. State can make law. Like at any places, if people are restricting somebody of their own religion, then the state can interfere and make law so that there will be no discrimination. Next is Article 26, that is freedom to manage religious affairs. Article 26 guarantees to every religious denomination or section thereof to right to manage its own religious affairs subject to public order, morality and health. As long as your religion or your practice of religion is not affecting the public order, it is not disturbing it, and it is not being immoral, or it is not causing any health hazards to others or to yourself, you can freely practice your religion. So it includes your 4 specific freedoms, that is, you can establish and maintain institutions for religious and charitable purposes, to manage its own affairs in matters of religion, to own and acquire movable and immovable property, to administer such property in accordance with law. According to the law, you can do anything. In short, Article 26 allows religious groups like temples, gurudwaras, mosques, churches to run their internal matters and institutions freely as long as they respect public order and the law. Next is Article 27. That is freedom as to pay payment of taxes for promotion of any particular religion. Nobody is compelled to pay any taxes, and if they pay, the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. Basically, the state cannot force someone to pay any taxes to maintain or to promote their religion, because our nation, our country is a secular state. That is, the state does not favor or fund any particular religion. It treats every religion as equal. So, in simple terms, the government cannot use public money collected through taxes to support or promote any specific religion. It will not do that, according to Article 27. Next is Article 28. Freedom as to attendance at religious instruction or worship in certain educational institutions. That is, there are sub-clauses in Article 28. 28 Clause 1, that is, no religious instruction shall be provided in any educational institution wholly maintained by state funds. In simple words, in government schools and colleges, no particular religion should be taught to the children being educated there. So, no religious instruction should be given there in the wholly maintained government schools and colleges by the state. Next is Article 28 Clause 2. This restriction does not apply to educational institutions that are administered by the state but established under an endowment or trust that requires religious instructions. For example, there are Vedic universities where they teach Vedic studies. This kind of religious teaching can be continued because it is done for a purpose. Similarly, for other religions like Islam or Christianity or Sikhism or Jainism, Buddhism, they can establish their own trust or college or educational institution, and such kind of religious colleges or institutions, the Article 28 Clause 1 does not apply. That is the meaning of this Clause 2. Next is Article 28 Clause 3. That is, no person attending any educational institution recognized or aided by the state shall be forced to take part in any religious instruction or worship conducted there. In any educational institution, whether it is run by private or government, basically in private schools or educational institutions, no student should be forced to take part in any religious instructions, and participation must be voluntary. If they are voluntarily willing to participate in that instruction or worship, they can do so, but there shouldn't be any forceful compulsion on that student to take part in the religious instruction. So this is about all the articles for lecture 2. So next in the series we will learn about fundamental rights from articles 29 to 35. And so with lecture 3 we will be concluding with the fundamental rights. So till the end, thank you so much for watching. So those whoever watched till the end, please like the video, share it to your fellow aspirants, please comment and subscribe to the channel for more Indian polity lessons. Thank you so much. God bless you all. Jai Hind.